Hi, good afternoon, everybody, and welcome to Garfunkel Wild's 2023 ASC seminar. My name is Salvatore Puccio. I am a partner at Garfunkel Wild, and I'm a member of the firm's employment and cannabis groups, as well as our litigation and arbitration group. Based on the registration, I've had the pleasure of working with some of you folks and some of the ASCs that have joined us today, and those that I have not had the chance to work with. I look forward to receiving any feedback, questions regarding today's topic. And today I'm going to be speaking on marijuana impact on healthcare operations, and specifically discussing some of the updates that ASCs have been facing regarding medical and recreational marijuana. With respect to this topic, I've been asked to speak on it nationally a couple of times over the past few years, and the information I continue to receive from the attendees and the registrants at those programs is that the refresher is good. They like the practical examples I give. This area of law in particular is continuing to change and expand very rapidly. So while I'm recording this on September 19th, by the time this goes live, there may be some changes in the law, and we'll have an opportunity to address those at either the question and answer session, or you can reach out to me because, again, as I've done these presentations before, there have been changes in the intervening time period. So we're going to try to get to it because we only have a half hour and a relatively decent amount of material to cover. But just some learning objectives. I find it's helpful just to list these about what am I going to do in today's presentation? Why should you listen? Why is this one important to tune in, take some notes on? Again, we'll talk about some of the current legal atmosphere and trends, some potential legal scenarios. And again, I like to give some practical real life examples of cases that I'm either watching, personally involved in, or questions that clients like you folks have come to us with. I made it in a topic. There was a lot of requests on one of the last presentations I did regarding patient consent issues. I'm going to touch on that a little bit. Not something really to be focused on in this context. However, I understand it does come up, so we'll touch on it just a little bit. And then just, again, some general guidance and suggestions on best way to handle these types of situations regarding potential workplace issues involving marijuana. And I might use the term marijuana, cannabis, kind of go back and forth. I feel like cannabis is a little bit more formal, but either way, we're talking about the same subject matter. So, just some background. I'll go through this quickly. Federal overview. Marijuana is still considered a class 1 controlled substance, and the definition there, it has a high potential for abuse, has no currently accepted medical use and treatment, and there's a lack of accepted safety for use of the drug or other substance. And I point that out because, well, medically, we know that's not necessarily correct, and that definition seems pretty flawed when you look at it. And here's some history. In 1970, Congress studied marijuana. They actually determined it was not a Schedule I substance back then. However, it's continued to remain a controlled substance. There were some steps taken to try to relax enforcement in 2009. It was pushed forward for more enforcement in 2018. What we've really seen in the last 4 to 5 years, no enforcement or little enforcement in terms of this the criminalization, I should say, of marijuana. So some recently proposed legislation. There is the MORE Act. That's the most recent. It's got a lot of support. It's expected to make its way through the Senate at some point in time. And also, we expect there to be some regulation or some change in the regulation at the federal level. But they'll come back to it, why that's important. Now, separate from our federal standards that we have to keep in mind, and again, at a federal level, use of marijuana or consumption or possession is still illegal. But at state law, we've seen some really drastic changes. 47 states plus DC, other territories, have some form of law that legalizes marijuana, whether it's THC or CBD, something along those lines, a close relative of the component THC in marijuana. 38 states have legalized medical marijuana programs. 21 states plus DC and Guam permit recreational use. And I point those out because there's some differences in how you're going to handle it in your state. And I'm not sure, you might be in the tri-state area, you might be in the Southwest, you might be in the Southeast, might be middle of the country. But depending on what state you're in, there might be different laws for medical marijuana that provide some protection for employees. There might be laws on the recreational side, like we have here in New York, for example, that provide protections for employees, and how you as an employer have to handle that and deal with that. So, I think the last bullet is very interesting, how it's really gone up in a 2-year period from 13 states. Now we're up to 37, and more continue to change as we move along. So where does this leave us with this disconnect between federal and state law, and new laws being added to the books, states constantly changing their updates, passing new requirements, and case law? Case law is something in the legal world we talk about where a case gets up to a court or a judge, and then there's a determination about what does the statute mean, what does the new regulation mean with respect to, in this case, cannabis. So there is still a significant gray area in the law. And why is that? Well, because of the conflict between federal and state law, 1. 2, it's a relatively new area of law. And 3, it's subject to interpretation. As we start getting into some of this subject matter, you'll see that a lot of this is based upon reasonableness and perceptions and objective standards to determine if someone is under the influence, if there's a reason to use marijuana, if it's permissible because of a medical reason. And now you have to determine whether that employee or staff member has a disability that requires an accommodation. So all of those issues come together to make it still a little bit of a gray area. It's not black and white where we can just say, we're going to take a hardline stance like you used to, a drug-free workplace, and you'll see that topic come up a bit today. That said, we do want to come back to some fundamentals, right? And especially, we understand, we're healthcare lawyers here at GW, we get it. You're going to sit back and say, Sal, I still can't have staff showing up to work under the influence. What do you mean gray area? And you're right. We're not going to allow staff members to show up to work under the influence, especially our anesthesiologists, our physicians, people performing scopes and other procedures on our staff, on our patient base, right? That said, there are still other issues. We've had cases where someone comes in and says, well, I have my medical marijuana card here in New York. This goes back a few years. And, I just want to let you know that if you drug test me, it's going to come back positive for THC because I use medical marijuana because I have a gastrointestinal issue. And this is all the way up and down, from the physicians to the front desk clerks to the billing and collection people. We've gotten these kind of issues that have come in periodically for all staff members at your facility. And you have to understand how to adapt, how to deal with those, and what's the right and wrong thing to say in order to best protect yourself and avoid litigation or improperly firing someone or taking away someone's livelihood or reporting them. So I'll try to address some of those gaps in the employment area that we have, and those gaps are being closed. There are more and more legislation coming out, clearing up what has to be done. But things I want you to keep in mind when these issues come up in your workplace would be, is there an underlying disability that maybe is something we have to consider? Someone comes to you and says, I need to use marijuana before and after work because of this condition I have. Well, maybe that person qualifies as having a disability, and you have to allow that use off premises, off work time. Maybe there's some other accommodations you might have to start providing. So just things to keep in mind. You want to be preventative. We like to treat here like you do in terms of preventative legal practice, meaning we don't want you to come to us when you get hit with a lawsuit. We want to work in advance of that so you can avoid the lawsuit and issue spot. Accommodations you might have to make. Think about, is your testing protocol meeting the current standards in the state or jurisdiction that you're in? And state and city could even have different requirements. Are you following all appropriate safety guidelines to protect your staff members and protect your patients? So just little things like that to keep in mind. Now, I've been talking a bit about disability, right? So I'm going to shift gears and talk about the ADA. That's a federal statute, and it's defined broadly under the federal law. And a disability under the ADA might include treatment using prescription drugs. well, then that would seem to indicate that, well, if my employee is being treated for a condition they have with medical marijuana, that's a prescription, so the individual should be protected under the ADA. Well, not quite. The ADA still excludes current illegal drug use from their laws. And as I said at the top of this presentation, marijuana is considered illegal at the federal level. So no protections under the ADA. And what had happened was many employers just felt for the longest time, well, there's no protection under the ADA, so I really don't have to give you any type of accommodation, consideration for your disability. And they were right for a really long period of time. Now, however, there's a common trend among the states that laws are being passed that are changing that landscape, and you have to be aware of them. Now, we're a couple of years in on some of these, so you might be saying, well, we're aware of that. We've heard you talk on this before, Sal. But let me just put it in context in terms of where it sometimes comes up that you might not be expecting it and what to do in situations that maybe you do expect. So, I have the first bullet point here talks about testing and screening for marijuana and strict no hire policies for a failed cannabis test. Excuse me, I apologize for the cough. I've been dealing with the upper respiratory issue for the better part of a week and a half. New York, New Jersey, and Connecticut, for example, have laws that will restrict your ability as an employer to just say, out of pocket, we tested you, you came back positive for THC, we're not going to hire you. Now, there might be some different implications with respect to people who might be in a healthcare setting or providing specific healthcare type services or providing care to minors or the elderly. But as a general requirement, you have to start from the idea and understanding that just because there's a positive marijuana test, that's not going to be sufficient grounds to just deny employment to all your staff members. Again, we're not just talking about your physicians. We're talking about operations, we're talking about back office, front office, facilities, engineers. There's a long list of employees that you have to keep in mind. Okay, so there's also laws prohibiting employment discrimination for medical marijuana in particular for patients and caregivers. So let me give you a quick example on each of these of cases that we're tracking and following. So for one, there was a case brought in New York City, and those sightseeing bus companies that drive around, the tour buses, the red ones, and they have you can sit up top and sit down below, and they drive you around the city. Well, that company was testing all of its employees for marijuana and using that as a basis for hiring and firing. And a number of employees brought a lawsuit saying, hey, look, all I do is fill out the clipboard. They're the people that were on the sidewalk saying, hey, do you want to come on this sightseeing tour? Come on, join. Here you go. Sign up. It's $10. I'm going to give you a discount, right? We've all seen them. They've all stopped us walking around the streets. And those folks said, why are you testing me? I could understand you testing the bus driver who's going to be driving, and you don't want them to have marijuana in their system and be under the influence driving a bus. I don't drive a bus. I don't even go on the bus. I hold a clipboard. And the court agreed. And the court said, yeah, this is not the same. Sure, there's an exception under the law that allows you to test the bus driver, but the person on the sidewalk signing people up, that's discriminatory and it violates the laws of New York. So that was one example on a hiring policy that a company had to adapt to. Another is there was a lawsuit, or I think it's still going on, involving specifically the caregivers of patients, the topic that I have here in that second bullet. And what had happened there is that person was applying to be a police officer. I think it was out in Suffolk County. And after a background check, it was determined that the individual's mother-in-law had a medical marijuana card and used medical marijuana. And his wife had been helping take care of the mother. She was in the house living with them. It was a disputed fact whether or not he tested positive for marijuana. He had argued that, well, if I did, it was because of the transfer from being around the person. It's not me. I'm not doing it. And a lawsuit resulted. And the defense from him was, the individual, you can't discriminate me because I'm a caregiver for a patient who's using prescription marijuana to treat a medically diagnosed condition. So whether it's right or wrong or how that's going to shake out, I'm not sure. I tend to believe the court should find in favor of the individual because if he's a caregiver, there are protections. But it just goes to show you that there are other levels that you have to think of that you might not be considering. So These are just some considerations, that we put together. Zero tolerance, illegal drug policies, right? Because now, if in your state marijuana is considered legal and you have a ban against legal drugs like marijuana, that's going to be a violation. So you really can't have a general zero tolerance policy. You can have a drug-free workplace, right? That's going to be okay. Accommodation requests. What do you do when someone comes to you and explains that they have a disability or condition that requires the use of off-duty marijuana to treat that illness? Crohn's disease, colitis, stress, brain injuries, cancer. There's a long laundry list of conditions that are accepted in New York on the medical side. And if someone does come to you with those issues, you have to consider that. You have to engage in an interactive process to determine if they can use off-duty medical marijuana, or maybe even recreational marijuana at this point in time, in order to treat that ailment, so long as it doesn't interfere with the essential functions of their job. And that's going to be done on a case-by-case basis. So you should also start considering your internal enforcement. And what I mean by that is, and I always highlight this because I get it from an operations standpoint, there's revenue earners and then there's your support staff as well, right? So how are you going to treat those folks? Are you treating them differently? Are you treating them the same? In other words, if the front desk clerk tells you that they need to use marijuana to treat glaucoma issue that they're having, are you going to fire them? But the physician who says they need to use marijuana because they have Crohn's disease, you're not going to fire them. Now you're pinning them differently and having two inconsistent policies that, quite frankly, I don't think is fair, and I think you could come back to hurt you in the long run. So again, just all considerations to have regarding this topic going forward. These are just some state law enforcement issues I put out there, depending on where you are. Our registrations now are starting to expand, more nationally. So I do like to include these. I think it's important also to see other areas and other jurisdictions, what they're doing. But I listed a couple of states where state law hasn't really caught up with the programs and the use of marijuana. And what I mean by that is some of the states look to federal law and still say, well, there's no protections under the ADA, so you don't have to provide any accommodation for your employees if they're using marijuana, even off duty. Again, I'm talking off duty, not in the workplace. So, some of these states just don't protect it. And if you're an employee in these states and you're using marijuana, you're not going to have any protections. And if you're the employer, you can take a more aggressive adverse employment action. On the flip side, when you get back to the Northeast more so, and the tri-state area in particular, there are laws that are going to directly provide rights and accommodations to employees. And as an employer, you're not going to have that quick reaction of just terminating someone's employment or disciplining them because you believe they are using marijuana off duty, for example. So one particular law I want to talk about a little bit, and coming out of New York, this is one that came up a few years ago. Marijuana Regulation and Taxation Act. And this is the one that really set forth the bar here in New York, that provided protections for employees, for staff members in New York if they were going to be using marijuana off duty, either recreationally or medically. And just some caveats. So an employer may take adverse employment action where required by federal or state law, or if it would violate such laws. That usually comes up in the context of like the CDL, your drivers, bus drivers, train operators, etc. Would lose a federal contract or funding. I'll throw a question out here that I'm expecting from folks, is on the funding. Is Medicare going to consist of? I get Medicare dollars. Is that a reason for me to say I have to follow federal law and drug test and fire everybody? No. Information has come forward. It's not. That's not the type of situation. It's not directly related. There was a case out in Arizona where a district judge in federal court said, no, that's not the type of association that is implicated in these type of laws. So you're not going to be able to say you get Medicare funding and therefore you don't have to follow the MRTA. Great argument. If we were faced with it, we might have to make it, but I don't think it would hold up long term. But the next two bullets are really the main points of where you can take some type of adverse employment action. And that's when an employee manifests specific symptoms of cannabis impairment that decrease or lessen that employee's performance. and that the employee while working manifests specific symptoms of cannabis impairment that interfere with their obligation to provide a safe and healthy workplace. So again, those are going to be the points where you look to say, you know, Sal was under the influence in our ASC and he couldn't administer care to a patient. He couldn't properly register the patient, couldn't provide the service. Therefore, I get to take adverse employment action, and that would be legal under this law in New York. Okay, so if faced with this one in New York, and Jersey, Connecticut have similar statutes, and it's the similar kind of do's and don'ts that you have. But what can you do? Well, you can require a drug-free workplace. You know, you can have a policy, and we'll show you some sample policies at the end here that specifically say you're not going to come to the office under the influence of anything that's going to impair your ability to safely treat our patients. You can prohibit possession of cannabis in the workplace, similar to policies people have regarding limiting possession of alcohol in the workplace. And I think that's good practice to put those in your policies now, because you don't want to have the question or suspicion of, well, what is someone doing with gummies in their locker, or you know, liquid or tinctures or pens, vape pens. Yeah, keep it out, keep it home, keep it in your car, keep it away from the workplace. Now, some things you cannot do. The New York laws and Jersey as well are specific to say you can't use smell alone to prove a sign of impairment. I'm going to come back to some of these objective signs of impairment in the next section, but you can't use smell alone. I address it here because this is where I usually get the questions on this. You know, you can't drug test for cannabis in the moment as the sole basis to determine that you are going to terminate someone. In New York, in fact, the regulation referenced that you can't drug test at all as part of your investigation. You cannot ban cannabis use outside the workplace in New York. So again, this comes back to what we said. We can't have a blanket policy that you're a drug-free workplace. Can't ever use drugs at, you know, using marijuana. You can't use marijuana now at home. And, you know, one of the last comments under the MRTA in New York is you don't necessarily have to terminate someone's employment. You can give a warning if you want to, rehabilitate the person or excuse it, but you're going to have to analyze that situation where it might be a case that you do go nuclear, for lack of a better term, in terms of one and done. Someone is impaired, you fire them. You know, that's something to consider. And it also depends on, you know, levels of impairment. Someone could come to the work with a bit of a hangover or some of the effects of their medical marijuana that they used earlier in the day to treat a symptom of their condition. So these are considerations that we don't take lightly. We understand how real and significant they are, but they're considerations that now require a little bit of consideration and investigation. What about CBD? You know, we're short for time, as we always are on these. So I'm not going to talk much about it, but, you know, there are some different rules and regulations. CBD is not illegal at the federal level, so it's a little bit more permissive. At the state side, same thing. If you have THC, that's going to be permissive. The CBD certainly is too. But I flag it because sometimes we get issues with it. Again, if the CBD or alcohol or Percocet or any other type of drug or recognized narcotic is impairing a person's ability in the workplace, well, you're going to step in and you're going to deal with that independently. Now, what do we do with dealing with these signs of impairment? Let's say someone comes in and you think they're under the influence, right? And let me give you a quick case example. We had a client out in New Jersey, got a call late on a Friday. It's always late on a Friday, right? And they call up and they say, we got 2 employees. It wasn't a medical facility, but similar, you know, the principles are the same. We got 2 employees. The manager, supervisor saw them get in a car, drive around the block, and they were passing back and forth what he described as a marijuana cigarette, and he observed them to be under the influence and called them in. We questioned them. One got up and literally ran out, just walked right out the door, gone. The other one wouldn't say anything, wouldn't answer questions, refused to do anything. So we want to fire him. Can we fire him? And this was right on the heels of passing some new legislation. And we said, well, you know what? The standard requires you have to demonstrate their articulable symptoms of impairment. And not one specific test or factor is going to be dispositive. So, of course, what did they want to do? They wanted to break out the drug test. And they said, let's drug test him. Let's find out if he tests positive for THC. If he does, we'll fire him, right? And I said, well, think about it. we know marijuana could stay in the system for 21, 30 days, right? And they said, yeah. I said, okay, so you test him. His attorney, it could be a first-year attorney, could throw that test out and say, he smoked marijuana 3 weeks ago, 6 days ago. It doesn't mean it was in his system today. All you had was a guy seeing him pass back and forth a marijuana cigarette in the car. What if they were passing back and forth a cigarette in a car, or tobacco, or something else? And they said, okay, well, what do we do? I said, well, similar, unlike alcohol, right? Alcohol, you can do the breathalyzer and it's easy. We've got to look into some signs and symptoms that we can point to. So we went through this and we talked about, what are the objective indications that the employee's performance are being lessened? And, went through looking at their eyes. How did he look? How did he sound when he talked? We did use the fact that they were passing a cigarette back and forth, or a marijuana cigarette back and forth, to be more along the lines of sharing a joint as opposed to sharing a cigarette. That was a factor. But we looked through all these other factors. Smell, right? They stunk of marijuana when they came in, as reported by several of the staff members. Now, smell alone is not going to be dispositive, but that could be a factor in terms of why you think the person was under the influence. And we went through all this, and ultimately they were issued a disciplinary notice. In this particular case, because it wasn't high stakes, it wasn't like a healthcare setting, they ultimately issued a significant reprimand, warning, suspension, and gave the person a second chance. I'm not saying you would end up that way, but it might be a consideration. So these are just some things to consider in terms of what you can do in order to determine if someone is under the influence. Quick warning, some of these signs that you look at, tiredness, could be indications of an underlying disability. So that's why you can't just pick one and say, oh, the person looked tired, they're high, they're under the influence. I have a client right now that's dealing with an accommodation of someone who falls asleep on the job because they have an underlying medical condition that they take medication for, and a side effect of that medication is they fall asleep. It's a form of regarding their underlying condition. So, you can't just take one factor and say, well, they were high. So, we're talking about this New Jersey example. New Jersey really went further with that, and what they did is they put into place, they want supervisors, there's a program called WIRE, W-I-R-E, where they have an independent person you're going to have hired in your facility that's going to determine if someone is under the influence. And they put out some rules and regulations on this, and I think I have here, here's the WIRE workplace impairment recognition expert. It took months and months and months for this to come together, but what New Jersey ultimately did was they came up with a great model. I think this is very good. Reasonable suspicion observed behavior report. This is a sample form. What I've been recommending to clients is come up with something similar to this. When you're going to deal with these signs of impairment, and you could see it on the screen, and if you can't, I can get you a better copy where you can zoom in or enlarge it, but they have references here to the physical symptoms such as, the bloodshot or red eyes, glassy, watery eyes, closed eyes, droopy eyelids, dry mouth, disheveled appearance, frequent sniffing, odors. It's a long list of behaviors and symptoms that can help support a objective finding that the person was impaired. And what you would do is you would describe the situation, provide the factors, circle all those factors, and then you can reach a conclusion based upon the totality of the circumstances that it was determined that, in our experience, this person or persons were under the influence of a drug, cannabis, alcohol, whatever the case may be. Now you have some objective evidence to defend why you took an adverse employment action against the person. So documentation, again, helpful just to document this. Always have it in writing. We always come back to that. I'm sure some of my other colleagues who are going to talk about HR updates and program requirements would have this, will remind you of this. So just remember to keep that documented. Accommodations. I just want to touch on this because, again, certain of the signs or symptoms of someone who is using prescription marijuana, medical marijuana, might require some other underlying accommodations that you have to consider. One is, like we're talking about, off-duty use. Others might be, sitting closer to the bathroom, taking other steps to protect someone, time off, break time, sleep breaks, things like that, that might also come into play. we talk about this, and it's not in a vacuum. We understand that there are talent shortages and staffing shortages. So we bring it up because a lot of times employers call us and say, look, so-and-so tested positive for marijuana or showed some signs or symptoms. Do we have to fire them? What do we have to do? We're short. No, you don't have to. If it's a patient safety issue, yes, you have to. You got to intervene. And that might require reporting a physician, getting them help, getting them in a treatment program. But not all instances are going to require that unless, again, they're impaired on the job and causing patient safety concerns. I don't want to mix it up here. We take that seriously. I'm talking more about maybe a front desk clerk, a biller, or a collector, or some kind of administrative assistant. So we've talked about some of these issues. This is a common case example that we get, where a physician is offered a job, and they're tested, comes back positive for marijuana. What do? Do you want to keep that physician? Do you not want to keep that physician? Again, as a basic premise, you're not going to use positive THC as a threshold requirement. However, there might be an exception because it's a physician or the nature of their service at the ASC that laws would allow you to make an adverse determination or not hire that person. We had this case come up before that MRTA came in, and the ASC was able to turn down the person's employment. But do you want to lose that talent? Do you want to lose that individual that you just recruited and offered a position to? So a lot of considerations to make. One thing always important to keep in mind, you want to try the best you can to treat the top earners the same as the front desk person, the back office person, the person who's doing the janitor cleanup as well. I'm going to skip this topic. Best practices: keep cannabis out of the office, just like you do with alcohol, right? Make that clear. Research and careful selection of the type of drug testing you're going to use. Stay on top of what's permissible, what's not permissible. I'm starting to see companies come out with same-day marijuana tests. How reliable are they? I don't know. I don't know that they'll stand up in court, but it might be an indication of something you can use in states that do permit that outside of New York. So New Jersey, for example, might permit that type of test. You have to be determined. Consult with GW about relevant state laws where you are, where you're going to set up practices in terms of what are the protocols for testing, policies, hiring, firing. A lot of folks are trending towards training managers to spot signs of impairment. I think that's cautionable. I don't like it. What I would suggest there is you give a little bit of training, but don't make it a focal point. Use that objective chart that we came up with, that we talk about, to be a little bit more of a guide. Patient consent issues, how to handle them, similar to workplace abilities, capacity to consent must be viewed on a case-by-case basis. So what I mean by that is you can't just take it generally and say, well, someone checked off the box, a patient, that they use marijuana, we can't do the test. No, it's in the moment. At that moment, are they able to provide consent? Can they give informed consent? And I think you guys mostly do a great job with this. I know myself, I've gotten called from ASCs, hospitals, when I've had to undergo some GI testing in the past few years, and they ask a lot of questions, and I'm the type of person who asks questions back. So I've asked questions back and said, why are you asking me all this about my cannabis use and whether medical marijuana and history and this and that? And they first get a little taken back, and then I explain, well, look, I'm an employment lawyer, I deal with this, I'm curious, why are you guys doing this? And I get good answers. And what I got recently was, well, from an anesthesiologist who I was questioning as he was questioning me 6 minutes before my procedure. And he said, well, look, if you use marijuana and it's in your system, you could have an adverse effect. Right. I said, okay, I got that, but I'm not. I haven't, what's the big deal if I used it 6 days ago? And he goes, well, if a patient did come in, it could affect how quickly they wake up from the anesthesia. It could affect how much anesthesia you need. There are different tolerance levels. So in order to get a baseline on a patient basis, they're asking these questions. And all I thought was, well, that's great. I think that should be explained to patients because they'll be more willing to share. Some patients are still going to feel that there's, a negative inference about saying they use marijuana, whether recreational or medically. So you have to be careful, keep that in mind. But the bottom line is, consult your local jurisdiction rules on capacity to consent. Those same rules would apply in this context, whether it's marijuana or other drugs or alcohol. Nothing really variable or different. I think the teach back technique that I came across, to me, seemed very good. Talking it back, explaining the situation, having it come back, really seemed to be a great use or process in order for determining whether someone has capacity. So updating your policies, I think you should update your handbooks to the extent you haven't. Every couple of years, you should do it generally. With respect to the cannabis issue, there are some topics now you want to highlight. I've seen policies that said, this is a drug-free workplace. If you're using marijuana, blah, 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 blah. Well, now you can't say that. You've automatically discriminated against staff, and it could be used against you in a lawsuit or Department of Labor or Division of Human Rights investigation. So you want to change that, tweak the language. You also want to make clear, and we have some sample policies you guys can go through on your own or ask about, that specifically say, being under the influence is a violation of our workplace standards. Get it out there, say it, make it clear. I mean, not that it shouldn't be, but we've had situations where folks have come to the office and said, well, I have a medical condition. My doctor says I can use medical marijuana. I use it to calm down my stress, to help my bad back, and I need it, so there's nothing you can do. Well, guess what? There is something we can do. You can't show up high or under the influence where you can't perform your duties. So put it out there, get it in black and white, let people know, and then you can point back to it later. So those are some of the sample policies. There's a lot more here we can talk about and get into. We're keeping this short to move it along for everybody. So I thank everyone for their time. I'll be available either at a Q&A session that we may hold, or separately if you have questions or you have particular issues that come up. I enjoy the topic. I can learn from it, learn from you guys, and hopefully impart some wisdom and help prevent any problems in the future. So with that said, enjoy the rest of the programs and sessions. Sorry if I went over a few minutes, but I did want to cover some of the material, and I look forward to seeing everyone in the near future. Thank you.